Okay, go ahead.
Hi, this is Steve Dean, and my group is doing tort reform in the healthcare industry. Unfortunately, I am the whole group. Apparently, this topic scared people off, but once we've gone through it, I think you'll be really excited. It's very interesting. I'm a police officer, so I do the criminal side, so this is the civil side. So here we go. First, let's talk about what's a tort. A tort is a civil wrong other than a breach of contract. Torts include negligence, false imprisonment, assault, and battery. The elements of a tort are a legal duty owed by the defendant to the plaintiff, a breach of duty, and damage from the breach of duty. A tort may be constitutional, in which one person deprives another of a right or immunity guaranteed by the Constitution. Personal, in which a person or person's reputation or feelings are injured, or intentional, in which the wrong is a deliberate act that is unlawful. Many other kinds of torts exist. Okay, if you're like me, this was way too long and way too legal. So I kind of made it a little bit simpler and looked for another definition. So here we have tort is a part of the law for most harms that are not either criminal or based on a contract. Tort law helps people to make claims for compensation or repayment when someone hurts them or hurts their property. This one was still pretty easy for me, but I wanted it even easier because that's how I work, real easy. So basically, in simple terms, it is a civil lawsuit one party brings against another party for harm or injury. There are two types of torts that we deal with, which are intentional and unintentional. Intentional torts are when someone intentionally hurts another person, and this is more probably towards the criminal side, a battery, assault, those type of things. Unintentional torts are acts not intended to cause harm, but it's committed through negligence. And this is probably more of the healthcare arena for lawsuits and so forth. So now that we have that, let me give you an example. So a patient has abdominal surgery. They wear a red band on their wrist that shows that they're allergic to the plastic tape that hospitals typically use. The surgical staff uses the plastic tape anyway, and it's used to hold the gauze down over the stitches. Later that day, when the patient finally awakes, he realizes the issue and has a nurse change the dressing. His skin's all blistered, and his wound took an extra week to heal. The patient files suit because the medical staff ignored the red allergy wristband and used plastic tape on him. So, what does tort reform in the healthcare industry mean? It basically is controlling the amount of money someone can file suit against a doctor or medical facility for. It caps their exposure. There are valid arguments on both sides of the issue as far as capping. Those pushing tort reform in the healthcare industry will often bring up the frivolous malpractice lawsuits as a reason why healthcare reform is necessary. I think it's extremely hard to make a decision about something without the facts. Tort reform obviously is no exception. So I'm going to start with a famous lawsuit that I would think is almost like a poster child for frivolous lawsuits. And that is the McDonald's hot coffee lawsuit that happened several years ago. And for those that don't know it, I'll explain it. In 1992, a woman spilled her cup of McDonald's coffee onto her lap, sustained burns to her groin. She was awarded 2.7 million in punitive damages by an Albuquerque jury, which was later lowered by a trial judge. I think he lowered it under 600,000. I would think a typical reaction might be McDonald's didn't spill the coffee. Why should they have to pay? I mean, isn't coffee supposed to be hot? I had similar thoughts until I got a little bit more information. So what the jurors and public didn't know, she was a 79-year-old woman, passenger, in the parking lot, and she's taking the lid off of the coffee to add cream and sugar when the cup tilted over. The coffee wasn't just hot, it was extremely hot. McDonald's corporate policy was to serve coffee at a temperature that would cause serious burns in a matter of seconds. to forward a specific business model calculated to control the consumption of refills. Its operations manual dictated a temperature of 185 degrees Fahrenheit, which causes third-degree burns in 3 seconds. McDonald's admitted that they knew about the risk of serious burns for over 10 years due to more than 700 claims and lawsuits involving hot coffee. The jury found that McDonald's had a callous disregard for the safety of the public. So McDonald's knew that the temperature was way too hot, but they made a budget decision, and that's what ultimately cost them. Now, the reason I brought this up, it's really not in healthcare, but I think a lot of people use lawsuits like this that they've heard about, and that's kind of the paradigm that they'll look at a lawsuit through. So I think it's really important that we get the facts before we kind of jump to conclusions on it. So here we go. Healthcare tort reform. In 2006, Harvard School of Public Health studied over 1,400 closed medical malpractice files across the country. The study, as reported in the New England Journal of Medicine, found the following conclusion. Portraits of malpractice system that is stricken with frivolous litigation are overblown, and the malpractice system performs reasonably well in its function of separating claims without merit from those with merit and compensating the latter. Insurance industry lobbyists that want caps on lawsuits quickly point out that 4 out of 5 verdicts in favor of defense are sure signs of proliferation of frivolous lawsuits. What they don't say is 95% of the cases are usually settled prior to a verdict. So the 4 out of 5 are only really applying to the 5% of cases. So what we're saying that 95 cases have merit, 5%, 4 out of the 5% don't have merit. In 2007, the National Association of Insurance Commissions found that the cost of defending malpractice claims and compensating victims totaled a mere 0.3% of the U.S. healthcare cost. This is a small percentage, indicating if we did away with the malpractice claims altogether, it wouldn't really impact healthcare costs. While the percentage is low, it doesn't take into account the additional costs when doctors order unnecessary tests to avoid a lawsuit. This is called defensive medicine, and we'll get into that here. A new study led by Michael B. Rothberg of the Cleveland Clinic and published in the Journal of American Medical Association aimed at measuring how much defensive medicine there is and how much it costs. The researchers' conclusion is that defensive medicine accounts for 2.9% of the healthcare spending. Once again, relatively low percentage, but 2.9% of $3 trillion was the annual healthcare cost in 2014, which is a lot of money. So let's get into Texas healthcare tort reform. They're kind of the big guys on the block. Prior to 2003, Texas was known as one of the nation's judicial hellholes. State laws were not handled the same from court to court, or even in some cases, a court would handle them differently based on the attorney before the judge. Texas didn't get this reputation overnight. It had been struggling with judicial issues for many years, with many failed attempts to fix them. For example, in '77, Texas attempted to handle malpractice damages by passing its first tort reform law, which established a cap on all medical malpractice damages except for medical expenses. The Texas Supreme Court, who had been backed by plaintiffs' lawyers, held that the cap violated Texas Constitution's open courts provision. As a result, malpractice lawsuits took a big jump, as did the malpractice insurance rate, which meant doctors had to pay more for the malpractice coverage. In 2003, the Texas tort system was a mess. For example, 1 out of every 4 doctors in Texas had a malpractice claim filed against him or her each year. 85% of all medical malpractice claims failed, but still cost more than $50,000 to defend. The number of medical malpractice insurers in Texas dropped from 17 to 2,000 to only 4 in 2003, one of the four was the state of Texas as the insurer of last resort. Class action defendants almost always settled once the case was certified by the trial judge. Plaintiffs were given too much latitude in choosing which county to bring lawsuit. Thousands of non-impaired plaintiffs from all over the country were filing asbestos and silicosis and even industrial dust cases in a few Texas counties. As a result, doctors left the state, limiting their practice or many retiring early. Texas has one of the lowest doctor to citizen ratios in the country, and it was getting worse. Medical specialists were the target most often for these malpractice claims. Some counties were more litigious than others, which resulted in a void of specialists. For example, there was not a single neurosurgeon south of San Antonio. 100 counties didn't have a pediatrician, and 154 did not have an obstetrician. The unfair tort system was not just hurting the state's income, it was posing a severe risk to those Texans who most needed to see a doctor. Expectant mothers, children, those who were injured in an accident, those who needed specialists, and the families of patients were all paying a personal price for the lack of fairness in the Texas legal system. Because lawyers' livelihood rested on unbalanced court systems, they invested in the political careers of legislators to help to maintain the legal system as status quo. From 1988 until 2003, the trial lawyer lobbyists were so powerful, they kept legislation designed to help balance courts tied up in committees, or they defeated it. In 2003, Texas lawmakers under the direction of Governor Perry, who had made health care tort reform a state emergency, passed House Bill 4, which was known as the Omnibus Tort Reform Bill. The common sense reforms written in HB 4, which were designed to end legal gamesmanship, included: juries should hear more evidence about who may really be at fault. Only those individuals who caused harm should pay, and then only to the extent of their own fault. Damages should be limited to what the plaintiffs paid or incurred, or what someone paid or incurred on their behalf, thereby eliminating phantom damages. So phantom damages are damages awarded for medical bills not actually incurred. It is the difference between the amount a medical provider would charge a fee-for-service patient and the amount the plaintiff's insurance provider contracted to pay the medical provider. In most cases, it's a pretty big gap, and the claims would actually go towards that. So they call them phantom damages. In malpractice cases, a medical report written by a physician in the same or similar field as the physician being sued should be submitted within 120 days of the filing of the lawsuit, clearly identifying the appropriate standard of care, how the standard of care was violated, and the damages that resulted from the violation of the standard of care. Non-economic damages should be capped at $250,000 for any and all doctors sued, with an additional cap of $250,000 for each of up to 2 medical care institutions. The legislation also stopped venue shopping, which has been used to help tilt the scales in favor of trial lawyers. Those who don't know venue, basically it's the location where the trial is held. HB 4 has been referred to as a model bill by a number of commentators because it addressed so many procedural, substantive, common law, and statutory law changes needed to bring the court system in Texas back into balance. HB 4 didn't contain particularly new or innovative ideas. Instead, the reform was a model because it used laws that had been adopted by other states, procedures used by the federal court system. The thing unique about it was there was so many different things all put into this one bill. 4 years after Texas voters approved a constitutional amendment capping medical malpractice lawsuits, doctors began returning to the state. Many rural areas that had been without doctors for years began to enjoy having healthcare professionals in their towns once again. Now, I'm sure there's numerous reasons that doctors came flooding back into Texas. I'm just saying that this obviously was one of them. The reform bills had an unanticipated result of an economic increase while giving better access to healthcare. 10 years after HB 4 was implemented, the number of licensed physicians would have almost doubled. The Christus Health, a nonprofit Catholic health system with hospitals throughout Texas, saved so much on its liability costs that it expanded its charity care by $100 million per year starting in 2004. Texas Children's Hospital is completing a multi-billion-dollar expansion that it could not have undertaken without the lawsuit reforms in HB 4. Now, while you could argue numerous things could have happened to cause this, I think we have to acknowledge that HB 4 was obviously one of the important things, if not the main thing. Individuals have seen their lives improved as well. Consider the case of George Rodriguez, a man who lives in Corpus Christi, a city that did not have a neurosurgeon before HB 4. One day, suffering from back pain, Mr. Rodriguez went to the emergency room and was seen by Dr. Matthew Alexander, a neurosurgeon who had moved to Corpus Christi from out of state and had opened his practice 1 week before, specifically because of HB 4. Turns out that Mr. Rodriguez had a spinal abscess, a life-threatening condition if it wasn't treated within the hour. Obviously, Mr. Rodriguez is with us because of Dr. Matthews. If this had happened 2 weeks prior, Mr. Rodriguez most likely would have died. The Texas tort reform obviously helped save Mr. Rodriguez's life. In 2003, Texas physicians were paying about the same malpractice rate as were doctors in New York. Physicians were struggling to pay their malpractice premiums and keep their practices open. A crisis in access to healthcare was facing both states. Texas chose to adopt reasonable, common sense law reforms. As a result, the malpractice insurance premiums paid by Texas doctors have fallen more than 60% on average. Consequently, most Texas doctors are paying less than half of what they were paying 10 years ago. In contrast, malpractice premiums in New York have increased by 60%. As a result, almost 2,000 physicians have moved their practice from New York to Texas. Insurance companies have to be a good resource for judging tort reform. Dropping the malpractice insurance rate seems to mean that it's working. 10 years after the Texas legislature capped damages in the state's medical malpractice lawsuits, the number of suits and the amounts paid out have fallen sharply. Supporters of tort reform law say doctors worry less about being sued and have seen their malpractice insurance premiums fall. Opponents counter that tort reform has barred many injured by doctors from going to court or relatives suing after losing a loved one due to medical malpractice. In the 4 years prior to the law, the average Texas doctor covered by the state's largest malpractice insurer faced premium increases of 147%, according to the Department of Insurance. In 2003, an average malpractice insurance premium fell 46%. The law took effect on September 1st, 2003, and limited damages for pain and suffering in most malpractice cases to $250,000. Texas is one of 31 states to cap damages, though there is no limit on economical damages like reimbursement for medical bills or lost wages. Here's an example of the various states. Texas tort reform, while it may not be the leader, in healthcare tort reform. They have made a significant impact in U.S. healthcare reforms. The above figure shows that numerous states are addressing healthcare tort reform. And with very few exceptions, most of them, it seems to have a cap around 250,000. So somehow that's the magic number. Some of the law's fiercest critics, meanwhile, have been trial lawyers who say those injured or the families of those killed who don't earn a lot of money, which are children, retirees, disabled people, and nursing home patients, can't get attorneys to take their cases because they stand little chance at big payouts. The Texas Medical Association reported that since 2003, the state has licensed more than 28,000 new physicians, about 3,135 per year. That's over 770 more than the average in the 9 prior years since they started capping damages. All these arguments are very good and most likely have some validity to them. The overall measure whether tort reform works or has not has to be driven by money. Money was the thing that drove the lawsuit frenzy, which drove up the cost of insurance. With the price of insurance dropping, I think one has to acknowledge that tort reform has worked at some level. Doctors bring up that they practice defensive medicine, which is basically doctors ordering extra unnecessary tests to protect themselves from costly lawsuits. There's very little data establishing how big or how small this problem might be. A recent PricewaterhouseCoopers study estimates that these practices are responsible for up to 10% of the country's annual healthcare spending, or some $210 billion. These numbers, they seem significant. So one question I would have is, why didn't the Affordable Care Act address it? President Obama argued in a speech to the AMA that caps on malpractice awards can be unfair to people who've been harmfully wronged. Many Democrats agree, as do plaintiffs' lawyers, who've generously given to Democratic campaigns, including President Obama's. I'm not sure how the Affordable Care Act could have been created or could have created such a comprehensive overhaul of healthcare and not address some limitation of damages. One would think capping damages would be at the forefront of Obamacare. Instead, it seems to have been ignored. According to the Open Secret Organization, which is a nonprofit, since 1990, the American Association for Justice, previously known as the Association of Trial Lawyers of America, has given 92% of its $36.8 million in contributions to Democrats. The association is also a large contributor to President Barack Obama's re-election campaign. It is opposed to malpractice tort reform for obvious reasons, and I suspect that it may have played a significant role in the absence of malpractice liability reform in the Affordable Care Act. Do we need healthcare reform? I think arguments can be made on both sides. Using Texas as an example, I think there was an overall improvement in the healthcare system as a result of the reform. And then the last page is just references.
Awesome. Great work, Steve. You really did an in-depth coverage of tort and tort law. I mean, that really excellent job. It really is an important topic to discuss and a really hot topic in healthcare to determine, which way we should go. So really great job. And it sounds like you learned a lot as you were studying that topic. You know a plethora of information now. That's awesome. But so my question for you that I ask most everybody when we're done with the presentation is, what was the most interesting thing that you learned as you were studying this topic?
I think it was the lack of studies done regarding those people that are affected by caps on malpractice. They talk about the poor and children and relatives not able to sue because there's a cap, but there's really not any studies that address that and look at it. We have tons of studies talking about how the caps have really helped, but nothing on the other end. And you would think that the attorneys that don't want caps would have addressed that, but I couldn't find anything. It was really kind of surprising for me.
Gotcha. Yeah, no, that's a good point. I mean, it'd be nice to be able to see some of those studies out there that show that. All right, so I'm gonna go ahead and stop recording, but hold on the line for just a sec.